adjournment request?
Please, Your Lordship. Lordship, with the consent of other side, I would like to mention item number 5 to 7.
5 to 7.
7, Your Lordship. My senior, Mr. K.K. Mohanta, is out of station, Your Lordship.
Yes. Who is for the respondents?
Government of Assam, Your Lordship.
Mr.
S. Gautam.
S. Gautam. Learned Counsel. Paying for the petitioners. Has submitted that Mr. K.K. Mohanta, Learned Senior Counsel, who leads him in the cases, is out of station on proportional reasons. Submitting so Mr. Gautam has paid for an adjournment, with the consent of the Learned Counsel for the other sides. As paid for, these are the cases after
2 weeks, Your Lordship, 2nd week of November.
2 weeks.
Oblige, Your Lordship.
May Lordship, my Lord, item number 9. My Lord, Mr. T. Islam, who is leading the case, due to his illness, he could not.
T. Islam.
T. Islam,
Illness.
my Lord. T. Islam, my Lord, he is now his illness, my Lord. So, my Lord, consent the other side, my Lord, after 2 weeks time may be granted.
Mr. Jade Hussain, Learned Counsel for the petitioners, has submitted that Mr. T. Islam, the leading counsel, Mr. T. Islam, is in this post and has thus paid for an adjournment with the consent of the Learned Counsel for the other sides. Poster. Considering the ground cited, the prayer for adjournment is allowed. Is the case after 2 weeks.
Oblige.
You're there.
I am for the respondent.
All the respondents.
Respondent number 812, respondent 81288.
Mr. So-and-so, your name?
D. Royal Lordship.
Look you. Side play number 2. You have to book it after. Yes, Mr.
Your Lordship's indulgence, I would like to mention item 2.
Item
Item 2.
2.
I am
Yes.
on behalf of Silchar Municipal Board.
Yes.
We could not file our affidavit yet. Can I play for 3 weeks time?
Who is for the petitioner?
Mr.
Mr. P.K. Raichudhary, Learned Counsel for the petitioners, and Mr. S. Dotto, Learned Senior Counsel for the respondent. Number 4 and 5 are present. Post of Mr. Dotto, Senior Counsel appearing for the respondent. Number 4 and 5 has prayed for an adjournment. Of the matter for 3 weeks in order to file a counter affidavit on behalf of the respondent number 4 and 5. Poster. The prayer is allowed to release the case after 3 weeks for filing of affidavit by the respondent number 4 and 5.
Can I pray for a date? Well,
Release the case on after 3 weeks. Date. Release the case on so and so. Yes.
Please, your Lordship, if you concern of the other side, I'd like to mention item number 1 of the daily list, my Lord.
1.
1, my Lord. Due to relocation of our chamber, our file got misplaced, my Lord. We need some time to reconstruct our file, my Lord, and to file our affidavit.
Mr. P.K. Bora,
Yes, your Lordship.
Learned Counsel for the petitioner is present. Post of Mr.
H. Burua, my Lord.
H. Burua, Learned Counsel representing the Finance and Taxation Department, has submitted that due to relocation of the chamber, the brief has been misplaced and I need some time to reconstruct the brief and to file a counter affidavit. Post of The prayer is not objected to by the learned counsel for the petitioner. Full stop. As the prayer is not objected to by the learned counsel for the petitioner, comma, is the case after 3 weeks
Yes, my lord.
as prayed for by Mr. Borgo. Full stop. The interim order passed earlier shall continue till the next day.
Lordship, there are some similar matter that may be tag along with this matter, Lordship. There are 4 other similar matter.
Hmm.
But for different assessment, that may be tag along, Lordship. I have prepared,
Affidavits are filed or not?
there, in that, in other matters, they have not yet filed a affidavit yet.
Let the, this affidavit be filed, then we'll take the matters.
Like, Lordship.
May I please lordship? May I please lordship?
Yes.
I beg to mention for listing matter WPC 1783/24.
A bit louder.
May I please lordship? I beg to mention listing a matter WPC 1783/24.
For what?
Land matter for orders.
What is the reason for listing order?
It is a land matter relating to settlement on 28th October.
Psychology. Yes,
May I please, Lordship? I have to mention for listing an item, Lordship. It's
listing an item for what reason?
For motion, Lordship, there is some urgency, Your Lordship.
Motion when?
Was tomorrow, Lordship.
Tomorrow.
We have filed the case on.
What is the subject?
The land matters, land matters relating to Lordship, our road has been blocked, Your Lordship.
Okay.
Okay.
For orders, item number 3.
May it please your lordship. Lordship will file a rejoinder today, Lordship, during the course of the day, Lordship.
Rejoinder
Lordship.
to the
Lordship to the affidavit in opposition filed by the state of Tamil Nadu, Lordship.
state of Tamil Nadu. Yes,
So, Lordship, I am appealing for response number 8, Lordship. There is some development, Lordship, today morning, Lordship, we came to know, Lordship, the elephant that was captive in Tamil Nadu has been again be subject to some cruelty, or Lordship. I would just like to. I think some observation may be needed, Your Lordship. Because Tamil Nadu, at one hand, is saying that they are not going to release the elephant. End of the day, the elephant is suffering, Your Lordship.
Let me explain, I'm appealing for the state of Tamil Nadu. As per the order of the court, we have annexed the medical reports in our affidavit. All details have been furnished. Elephant is properly well looked after. And as per the doctors, elephant is in fine fettle. That is one part. The second part, the latest, because this is the news report, it says elephant was shown an iron ankush during procession. This is what I've seen. I'll find out a lot from the government. Be that as it may, because on the last occasion, it was the state which had taken time for filing rejoinder. Now, whatever, my lord, I will have the instruction, and my lord, on 7th of November, the matter can be taken up. Lordship may try to finally dispose of the matter. Because earlier, on behalf of the PETA, submission was made that the matter may be referred to the high-powered committee, please. May be referred to the high-powered committee. Now, the state of Tamil Nadu has agreed to that, because that is in terms of the direction of the Supreme Court in other cases, not in this case. So we have agreed to that also. But whatever, not subject to what the rejoinder says, I don't know. Latest, I'll find out what the truth is, because it is elephant was threatened with an iron ankush. The news report doesn't say that iron ankush was used on the elephant. It is like threatening a child with a stick. So I think it is, things have been taken too far. So whatever, my lord, actually I'm not keeping well under compulsion, I had to come. Stitches in my mouth have still not been removed.
Mr. Das, you bring this because otherwise the newspaper report is hearsay.
Using of iron and push lordship.
Not used, threatened with iron. Not used. We'll find out, sir. We'll find out. I can't make a comment on that. Whether the journalist was present, he himself had seen it.
Third page, lordship, as captive elements are often conditions to the use of weapons, the mere sight and hit of an iron ankush can trigger a traumatic response in
Oh.
these sensitive
Right.
limits. The Rajasthan High Court has already prohibited the use of iron ankush on February 26, 2010.
Again, now the news report says was shown, threatened. That means it was not used. Rajasthan High Court said iron ankush should not be used. So what exactly is the meaning of the expression quote unquote used? Anyway, my lord, I'll find out the details. I can't really comment on the veracity of the whole thing. Could it be only on 7th of November? Let me recover also because my stitches. You want me to die or what? Yeah, come on. Under compulsion, I had to come. Yeah, let us be. I'm not taking time in this case. It is the state.
Oh, date is mentioned. No date is mentioned.
Find out, my lord, whatever. I'll
Yeah,
find out.
in a religious procession, during a religious procession in Tamil Nadu, chilling video, but no date is mentioned.
I'll find out.
Many things can happen in a newspaper report.
It boils down to the same thing again, lordship, it's like the.
Right, we don't know.
We make the elephant issue.
Make a statement or not that on that day, this kind of ankush is used or threatened to be used, right? Simply by going by this chilling video, but no date is mentioned. When the religious procession was held, and otherwise it is hearsay. No, court does not go by hearsay. Yes, when? The issue is when. Things can be deceptive also. We cannot go by videos and newspaper reports.
And my senior friend, also accepted that lordship.
He'll take instruction.
Well, naturally. Oh. Find out from the state.
But submit an affidavit if it is.
Better. They must say this on oath.
Today we are concerned with the rejoinder affidavit. If you want, we can post it in the next week. But to file an affidavit so that he can get a proper instruction.
My request would be, since the state is filing rejoinder today, if the matter is taken up on 7th of November, by that time I will also recover.
When?
7th of November, I'll be here.
Miss
Lordship P. Barua.
P. Borwa, Learned Counsel, by paying for the petitioner, has submitted that the petitioners as for Bishop Apostolios side is going to file a rejoinder affidavit to the affidavit in opposition filed by the respondent number 226.
Lordship, by the Lordship. Affidavit
to
by the
six,
two to
two to
six, two to
six.
six, Lordship.
During the course of the day by furnishing copies to the learned counsel for the respective learned counsel for the respondents. Postal. Mr. P.K. Tiwari, learned senior counsel, assisted by Mr. A.R. Gogoi, learned counsel for the respondent number 226, and Mr. D.J. Das, learned counsel for the respondent number 8 are present. Postal. It is submitted by Mr. D.J. Das, learned counsel, appearing for the respondent number 8. That news reports are published suggesting that the captive elephant is still being threatened with Ankush ANKUSH during a religious procession held recently. First of, he has submitted that he would bring the details in this connection by way of an affidavit, if so advised, within a period of 1 week. First of, as agreed to by learned, as sought for by learned counsel for the parties, list the case on 7/11.
Also, I'm very grateful, Lordship, Tamil Nadu government has already agreed upon the HPC, Lordship, that is High Court Committee. Can that observation be made, Your Lordship?
No, that will be decided whether to send it to the committee or High Court will exercise its power to bring it back.
On that, I will be arguing on the maintainability of that petition also. I've raised all these.
All things are open.
Deeply obliged, Lordship.
Item number 4 for hearing.
Please, Lord, matter relates to my lord that impugn order passed by the SLC, my lord, upholding the social status of the respondent number 7, my lord.
Hmm?
On last occasion, my learned friend, my lord, appearing on behalf of the Social Justice and Empowerment Department, supposed to brought the record, my lord, that inquiry part, my lord.
What is the matter about?
My lord, the social status certificate of the respondent number 7 as a scheduled class has been, my lord.
Scheduled
Cell-
class. Respond number 7.
7, my lord. And XR 14, my lord, the impugn order.
1 minute. 7, Prostin the collector. Okay. What is the impugn order challenged here?
My lord, the impugn order. was
Annexer?
The annexer, my lord, 14, page 53.
And
Order passed by the.
14.
53.
Annexer,
Five
page
fifty.
50.
T.
That respond number 7 belongs to SC community
SCM community, my lord.
that you are challenging.
I am challenging, my lord.
So what is the status of this proceeding now?
Proceeding, my lord, they are supposed to produce the record, my lord, relating to inquiry. Earlier, Zonal Court made a query.
This inquiry
My lord.
leading to the passing of this order.
Murder, my lord.
Lordship, these records are with tribal affairs, Lordship. So we have also submitted a document, Lordship, a letter that is hearing the record, Lordship. So either you have to make tribal affairs the party or
Any amended cost title is filed.
My lord,
Where is that?
my lord,
Okay, it is,
as per this, my lord, the parent department earlier, my lord, that is response number 1, my lord.
one minute, amended cost title.
But tribal affairs department has not been
Yes,
part of it.
submitted amended cost title. Response number 2, 3, and same is on record flag date. Now, who will be the concerned authorities?
But response number 2, my lord, 2 and 3.
2,
and
that is
3,
Principal Secretariat of Government of Assam,
my lord.
Department of Social Justice. Okay,
No, Lordship, social justice don't have the records, Lordship, which is
Huh?
with the, social justice don't have the records, Lordship. It is with the tribal affairs, Lordship.
My lord, prior to 2022, it
One
was a one department, my lord, bifurcated 2 department, my lord.
no, but court has observed something.
My lord.
You are C. Sharma.
Yes, Lord.
So Sharma, you submitted on 23rd April that Social Justice and Empowerment Department has been trifurcated or split into 3 departments.
Yes, sir.
That Department of Tribal Affairs, Social Welfare and Empowerment Department, and Department of Women and Child Development. But you did not mention that which department is holding the records.
Lordship, subsequently, we came to know that.
And accordingly, after your submission, they have submitted the amended cost title,
My lord.
including the Director of Social Justice and Empowerment as a party respondent number 2, right? Now you are submitting that
Yes,
it
Lordship.
is the Department of Tribal Affairs who will be holding the records. Are you a standing counsel of
No.
Department of Tribal Affairs?
No, Lordship.
Then it is difficult, Mr. Sonia. We could ask you to correct amended cost title, but if he is not the standing counsel of Department of Tribal Affairs, he will not be in a position to bring the records.
Then I'll make party to the, my lord, Department of Tribal Affairs.
Had he been counsel, we could have
My lord.
asked him to show cause why. But now he is coming with a submission that unnecessarily delaying the matter, Mr. Sharma.
But
since 2013.
We also didn't know it, Lordship.
Huh?
We also didn't, it was not in our knowledge, Lordship.
Whether Mr. R.M. Das is standing counsel of Department of Tribal Affairs?
No,
No. Ardhor. Can you call to expedite the matter to Ardhor, Mr. Ardhor? At least to expedite the matter. You file a cost title, amended cost title again. But you can hand over the brief to him, copies of the brief.
My lord, earlier Rahul Dhar appeared, my lord, when before bifurcation.
He will come up with a statement that he does not have
No
the
longer, my lord.
papers. It is sure,
My lord.
since he is a departmental counsel.
My lord.
Had he been a private counsel, he would have said that, yes, I had the brief. What to do?
My lord, I will make party to my lord.
You file an amended cost title.
My lord.
So you are sure
yes, Lordship.
that this present Department of Social Justice and Empowerment, is not the concerned department.
No, Lordship.
Okay, we'll record it.
My lord.
Heard Mr. M. Horonian, learned counsel for the petitioner. This welfare of plain tribes exist or not exist?
My now Tribal Affairs Department.
According to them, these departments has ceased to exist. Welfare of plain tribes and backward classes department,
My lord.
right?
My lord.
So you are making them as response number one.
My
You have to delete it.
My lord. To be replaced by the my lord Tribal Affairs Department, Commission Secretary.
And director is also changed.
Director also since member.
Yes.
There will be director of tribal affairs.
My lord, this is a notification, Director of Tribal Affairs. My lord.
Let us see. Mr. C. Sharma, Standing Counsel, Social Justice and Empowerment Department, Assam, for the respondent number 2 and 3. Who is the State Counsel? MS S. Sharma. MS S. Kaur, Junior Government Advocate, Assam, for the respondent number 4, 5, and 6. Anybody representing respondent number 7? Mr. P.A. Ahmed, Learned Counsel for the respondent number 7. Full stop. Mr. Sharma, Learned Standing Counsel, Social Justice and Empowerment Department, has reiterated his submission that the welfare of plain tribes and backward classes department, Government of Assam, has been split into 3 departments, namely 1, Tribal Affairs within bracket P Department, 2, Social Welfare and Empowerment Department, and 3, Department of Women and Child Development. Full stop. He has further submitted that though initially he was under the belief that the records pertaining to the social status,
My lord.
what is it called?
Social Status number 7.
Social status certificate of the respondent number 7 would be in the custody and possession of the Social Welfare and Empowerment Department. But on further instruction, he has learned that the records pertaining to the social status certificate of the respondent number 7 would be in the custody of the Tribal Affairs P Department. Full stop. And he would not be in a position to bring the relevant records. Full stop. He has further submitted that the Tribal Affairs P department has another set of counsels, namely Mr. Ardhar. Full stop. As the Tribal Affairs P department, Government of Assam, and the concerned director and the concerned directorate are not party respondents in this writ petition, comma, Mr. Hornia, learned counsel for the petitioner, has submitted that he would file an amended cost title.
Well, maybe department also, my lord, because the inquiry is conducted by the department. Committee.
No. I have said that the department and the directorate.
Well, and department means, well, remember, commerce again directed by the director, my lord. So both the parties, my lord.
Yes, I
Okay,
said
my
two.
lord.
I said concerned directorate.
My lord.
Comma. Directorate of Tribal Affairs within bracket plain. A concerned director, comma, I amended cost title within 3 working days from today. So some submission of such amended cost title, comma, the office to carry out the necessary corrections. Full stop, para. If Mr. Dhar comes, we can pass the order. Oh. Para. By which order records were called for? Which record?
My lord, record relating to the inquiry made by the state level committee, my lord.
By
regarding-
which order?
My lord, that, my lord. By 9, my lord, annexure 13, page 52,
52.
my lord. For verification of certain tax. Inquiry is made on 18/7/2013.
No, by which order records were called for?
My lord, that I couldn't do.
This.
The records called for the my lord.
Producers and if it is obtained records from the
Order
departments
passed
of
by the
produce
Mr.
the
Justice
records.
Barua, my lord.
No specific order. What kind of
Order is there-
record?
Order is there, my lord, but I.
Which order?
Right
Please
now. I
find
cannot
out.
recall it.
Please find out.
My lord,
Let us be specific.
my lord.
Again. By which order and what kind of record?
My lord.
Because there are many things. One is some office note, something. এখন দি দিব। থাকক এইটো 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 ৰাখি থকচোন আপুনি এইটো ৰাখি থওক ফাইলৰ লগত Mr. Horne, you can collect after some time.
My lord,
ফাইলৰ লগত থৈ দিব
my lord, I'll also take some time, my lord, to find out. I had to go to the all orders, my lord.
No time. We'll pass the order here. Or we can do that the relevant records of the proceedings
My lord,
which led to the passing of the impine order.
impine order, that my lord.
Mr. Dhar, I think you were earlier there. in this
Yes,
proceeding?
my lord, yes, my lord, when WPT
Since
was-
2013, this proceeding is pending.
Yes, my lord.
This is regarding that SC certificate, schedule caste certificate issued in favor of the respondent number 7. Then I think there is state scrutiny committee which held in favor of the respondent number 7. State scrutiny committee after inquiry. So Mr. Soronia wants the records of the proceedings of which led to the passing of the order by the state scrutiny committee. I think that is this record or the other record, Madhuri Patil kind of record.
No, my
Which record?
record regarding the inquiry, my lord.
Which one? Original or subsequent? There will be two kind of proceeding.
My lord,
One is the original issuance of SC caste certificate
my lord,
in terms of Madhuri Patil perhaps.
my lord.
Scrutiny
My
committee is Madhuri Patil, my lord.
And second is scrutiny committee. When you have made a challenge before the scrutiny committee,
My lord.
scrutiny committee has made another inquiry perhaps. Now, which one?
In terms of Madhuri Patil.
In terms of Madhuri Patil, but there was original one.
Yes, yes.
Which one?
Both the records, my lord.
Both are records. What you have been doing for last 11 years?
My lord.
After 11 years,
And my lord, the thing is that what is the locus of the petitioner, my lord, here, that he, because my Supreme Court has very categorically, my lord, has laid down, my lord, law, my lord. There are recent judgments, my lord.
okay,
That the locus, my lord,
you will be brought into picture in this proceeding only after passing of the order.
My lord, my lord,
Then you come up with all the arms and ammunition,
Ammunition, my lord.
my lord, my lord.
So he can shoot me, my lord.
right? You are not yet party,
My lord.
but to expedite the proceeding,
My-
you have been requested to appear so that Mr. Coronia can hand over the copies of the brief to you.
My-
Right?
My lord.
Okay. You be sure, otherwise we'll call for one record. I have not gone through the records.
My lord, records, my
Uh,
lord. Entire record.
Which records?
Record relating to my lord, his social status and inquiry made by the SLC.
SLC. Okay. Sunil Hasil. The subject matter of challenge in this petition is, in essence, the social status certificate issued in favor of page 23.
Respondent number 7, my lord.
No, page 23.
My lord.
Huh?
My lord. 8/2/2010.
Social status certificate issued in favor of the respondent number 7
As scheduled caste.
on 8/2/2010 as a scheduled caste. Within bracket, Koiborto. Full stop. When a complaint was filed, the state scrutiny committee under the erstwhile Department of Welfare of Plain Tribes and Backward Classes, Government of Assam, held an inquiry. And after an inquiry, it was held by the impugn order dated 14/8/2013 that the state level scrutiny committee had come to a conclusion that the respondent number 7 belonged to scheduled caste within bracket Koiborto community. Full stop. para. By various previous orders, by different previous orders, comma, the relevant records were called for. Full stop. As it has been submitted at the bar by the Learning Council for the parties today that the relevant records of the proceedings held by the state level scrutiny committee leading to the passing of the impugn order dated 14/8/2013, comma, is presently in custody of the Department of Tribal Affairs Plain, Government of Assam. Mr. Ardhor, Land Standing Council, Department of Tribal Affairs Plain, is requested to appear before this court today. On request, comma, Mr. Dhar, Land Standing Council, so and so, has appeared before the court today. Full stop. Mr. Hornian, Land Council for the petitioner, shall hand over the copies of the pleadings to Mr. Dhar within 2 working days from today.
Well,
Full stop. Para. Mr. Dhar shall obtain the records of the proceedings of the state level scrutiny committee, which led to the passing of the impugn order dated 14/8/2013 on the next date of listing. Full stop. Yes, now it is your turn. How much time you require? 2 weeks. Okay, agreed with it. November. 14?
Fine.
14? November?
well,
Okay,
It's a good day, Mali. Our first former Prime Minister's birthday.
okay. 14, list the
Well,
case on
well.
14. 11.
then I'll make 2 party, my lord, the Commissioner Secretary, representing the Tribal Affairs Department Director,
Don't default.
my lord.
My lord,
Well.
my name may be shown in the cause case.
Huh?
My
The name of Mr. Ardhor, Land Standing Council, Department of Tribal Affairs, plain, be reflected in the respondent side in the call list.
I love it.
Item number 8.
Yes.
May I please, Your Honor, Lordship, does the finance department has informed that they will put some time for this today. So.
Yes.
Council is not available.
Council is there.
I have
He has
requested-
taken time by his absence. Perhaps. By remaining absent, he has impliedly sought time, perhaps. Arbor Pujari,
Our authorization,
pay scale dispute.
Lordship.
The scale which was fixed, Lordship, there were certain anomalies according to finance department told that he is entitled to this much. Accordingly, this 10 lakhs or odd amount is to be deducted from his salary. That part also, Lordship. That is as per the direction of the finance.
Case is of technical resignation. Technical resignation. Okay, he was initially under CBI.
CBI. And there
CBI
he
is
got
under
it,
central government.
Lordship.
And after switching over to this post, he was under
State government.
state. So in a central post, it was central pay revision or whatever.
Yeah,
In the state, it is Assam
Lordship.
pay. Shortly.
Yes,
So when a person has technically resigned, Otherwise, there is no dispute that he is entitled for pay protection.
Yes.
There is no
No
dispute.
dispute on that.
If the person, when he joined the new post, in the central pay he is entitled, he is liable to be protected. Now, when he switched over, that kind of pay was not available. He was given the highest pay. Is it not? I think that is
Lordship. And
sum
the-
and substance of the story.
And according to the finance department, so far, I have gone through Lordship. As he has got that revision in the when he was in CPI, he already got that revision, so he is not entitled here.
No, then there is another story which has not been dealt perhaps. I don't know. I'm very weak in pay protection, pay metrics. I find it very difficult. We have to do the accountant's job,
Lordship.
which should be done by Mr. R.K. Talukdar properly. Huh?
Lordship.
Properly, I'm saying, correctly.
Correctly.
Many a times they try to defend the exchequer money without any rhyme and reason. Now, question is, come to one page, Mr. Talukdar and Mr. Sharma. It is right that a decision is taken, you go on supporting it. But decision is taken, but go on supporting without anything. That is wrong. Now, come to page 58.
I will. Lordship.
Initially, some revision was made. Pay revision, you said, that story.
Lordship.
But this is another document whereby his pay has been fixed. See the table, pay as on 1/7/2018, last row. Last row.
Lordship.
Pay as on 1/7/2018, that is prior to he joining the High Court. 17,220. So this has been passed after all these increments, central civil service pay rules perhaps. CCS RP rules 2008. So when his pay was revised initially, on the basis of which his pay protection was given, that was not final pay. Under the revised central pay. This is the final pay. Now, have any of the respondents have dealt with this particular document? Let us read, Mr. Sharma, this page 58.
Lordship. In pursuance of the Government of India Ministry of Finance, Department of Expenditure, New Delhi, White Office Memorandum dated 19th March 2012, under memo number so and so, granting one increment to government employees who were due to get their annual increment between February to June during 2006.
2006,
Lordship.
in the pre-revised.
Revised pay scale as a one-time measure.
And thereafter.
And thereafter, we'll get the next increment in the revised pay structure on 1/7/2006 as per Rule 10 of the CCS RP Rules
2008. This is also 2008.
Eight.
The pay of the
Sukmoy Day, SCS in the pay scale of 9,300 to 34,800 plus DP.
Is hereby fixed as per CCS RP rules. 2008 as
Yes.
under. Last row.
Pay as on 1/7/2009 on annual increment, total 17,220.
Then next, let us read next one.
Consequent upon his appointment for the post of stenographer grade 1 in the principal seat of Guwahati High Court, he has been relieved from this organization on 9/1/2009 on technical resignation.
So this 17,220 should have been the basis.
Lots.
Now, all these years, these proceedings for last 10 years,
Lots.
have any of the parties dealt with this issue? Mr. Talukdar? Because come to the Registrar General Order. Page 48.
Yes, madam.
Page 48.
Yes.
Please read.
This is regarding the fixation of basic pay in respect of Sri Sukhomoy Dev, who joined in this registry steno grade 1 through proportional on 9/1/2009. Sri Dev was holding senior clerk steno in the office of the Central Bureau of Investigation ACB Guwahati before joining this registry, and he was drawing his basic pay of rupees 12,660 plus grade pay of rupees 4,200, total of which comes to rupees 16,860.
Now let us flip to page 58.
There is a difference of 1,000 rupees.
Yes, madam.
12,660 here 1320.
Hmm.
Almost
1320,
500.
Yes, madam.
This is his 16,860.
15,860 here 17,000.
In the scale of pay of 9,300 to 34,800.
800 plus.
Thus, you see the scale just above the table, 9,300 to 34,800 with grade pay of 4,200. Right. His pay on 1/7/2007 was 16,710. And pay on 1/7/2008 is 17,220.
220.
But this pay fixation is for protection was made. Please read further, page 48.
As per his last pay certificate and statement of fixation of initial basic pay at flag so and so. But maximum scale of pay in the post of steno grade 1 now he joined as 11,825. That is so and so. Hence, he is drawing much more basic pay than maximum scale of pay of steno grade 1, that is rupees 11,825 of this registry. In such a position, he may perhaps be allowed to draw last scale of rupees 11,825, and in the meantime, government of Assam may be moved for fixation of the basic pay, my lord.
Now, if his page 58, Mr. Talukdar,
Yes, sir.
if page 58, 17,220 should have been the proper one, then it should be made relatable to the revised pay of the Assam government.
Government.
Why all these exercise? I'm in very simple terms.
Yes.
This is settled, 17,220.
17,000, yes, madam.
This has been fixed under CCA
Yes.
RP pay rules
2000.
2008. And his pay, there is no dispute that he, under the revised pay, 9,300 to 34,800 with grade pay of rupees 4,200. And his last pay was with annual increment 17,220. Thereafter he joined. Because all this pay come later on because of revision, all these pay anomaly, whatever. Ultimately, it is 17,220. Now, this should be made relatable in the pre-revised scale of Assam government or post-revised scale of Assam government. I am keeping it simple, Mrs. Sharma. All these rigmaroles I am avoiding. If Mr. Das is allowed, SK Das, he will lead me to a maze.
The issue is very simple here.
I am trying to making it simple.
There can be two fixations. Fixation already was done in CBI in the So. again,
No, CBI page 50, come to a page 50. Don't confuse now.
Sorry.
There should be revisit perhaps.
Yes.
Please read this total order, entire order.
Departmental inspection immediately by OM letters also under memo granting one increment to government employees who is due to get their annual increment between February to June.
All these are prior to joining. All this is prior to joining High Court. Though passed later on in the year 2012,
The last grade certificate given by the CBI.
that appears to be provisional. This is the final one.
Yes.
This is the final one. Nobody has dealt with it. See, 2006 pay rules are revised in 2010 and giving effect from 1/1/2006. The pay scales are like this. Revision of pay rules 2010 are pay scales are fixed and effect is from 1/1/2006. Whether area is paid or not, that is a different issue. But question is, pay scale is fixed from 1/1/2006, like that. So this pay scale fixation takes time. Pay anomaly committee, all these are there. Now here is a case of final order of his pay fixation under the CBI by this order.
One aspect of the matter.
No, please. Don't go, lead me to a maze. No. Now, I'm making it simple. You made all this pay protection by virtue of page 48 order. Right? Page 48, no dispute. Right. Now, this 11,825 was in the pre-revised scale of state government. Am I clear?
11,825, yes.
It was in the pre-revised scale of the state government.
Yes.
Am I clear? And page 58 or first part of page 48, this 9,300 to 34,800 was in the post-revised scale of the state government.
This is the revised.
That is a revised in the central government. Revised in the central government.
Yes.
Now tell me, please. Now tell me, please. Finally, the central government has come to a finding by page 58 that his pay as on 1/7/2008 is 17,220.
Yes.
Right. Now, this 11,825, right, by page 48, whether it was in the revised scale or pre-revised scale. My first query to all the parties.
I may explain.
No. Yes or no?
Saying yes or no, I'll have to take a lot of a little bit.
No. This is very clear. This data. No, Mr. 5,725 to 11,825. It is in the pre-revised scale or post-revised scale. You please tell me that can be answered in yes or no. Yes or no, which one? Pre-revised or post-revised?
So there is a problem here, Milo. If I may explain why I'm saying so, Milo.
Because, no, there is no problem because come to the bottom, page 48. it was in 2009. Now, revision of pay rules of Assam government is published when? So, where the Registrar General got that pay scale? Revised or post revised?
Just losing sight of one very important aspect of the matter, but it may not with regard to this last pay drawn by the petitioner, that is, my lord, last pay, 16860. As per his last pay certificate, his last pay was 16860. And this last pay was revised pay as per the ROP rule in the central government.
Mister, that is why I have understood your problem. This page 48, you're making whole submission on the basis of page 48. Now, why are you ignoring page 58?
So far as page 58 is concerned, this came subsequently.
Whatever.
For the record from the registry also, some fixation has been made after this change, so far as I remember.
No, see, please make it simple, don't make it complex. No, please understand my question. Please understand my question. When you made the page 48 pay protection order, this 9,300 to 34,800 plus grade pay of rupees 4,200 of the petitioner, as per his LPC, was revised central pay, right? Right? Now, at that point of time, thereafter, page 58, please read the totality, that Central Civil Services Revision of Pay Rules 2008, Rule 10, all these are taken note of, and finally, his pay is fixed as on 1/7/2008 at rupees 13,020 plus grade pay 17,220. Okay, so this was perhaps page 48 was some kind of interim, and page 58. Let me complete my page 58 is a finality, and that is according to central government. Now, when you translated by page 48, translated his LPC to provide him pay protection, did you consider the revised pay scale of the state government or pre-revised pay scale of the government? By page 48. Now it is an admitted position. I think it is a clear position otherwise, that his LPC was based on revised central pay.
Yes.
Let us keep it simple. And there were two fixations by initially that particular 16,860 at the time of by his LPC, which is annexed, I think here, page 46, right? And later on, it has been refixed by page 58.
Yes.
Simple. Now, when this revised pay, first revised pay, I'm saying 16,860 was translated state scale for the purpose of pay protection, whether it took note of pre-revised scale or revised scale. This 5,725 to 11,825 is a pre-revised scale or a revised scale. Take note of the date 15 to 2009.
Yes.
Because Assam revision of pay rules was published in 2010. Now tell me that first, yes or no? It is pre-revised or post-revised?
This 5725 to 11825, it's a pre-revised.
So after 2012, that's paid 58. And publication of Assam revision of pay rules 2010, it should have been tallied with the revised pay scale. No, simple thing.
Which query is with regard to page 58?
48 and 50.
Yes.
48 and 50.
Calculation based on the basis of last pay certificate, that is 16860.
But that amounts by page 58 ultimately it has been finalized.
Correctly, in page 58, the Ministry of Expenditure granted one increment, and that was added.
Then no plus Central Civil Services revision of pay rules 2008, because
No,
central government are faster than state government.
Can we read third line, granting one increment to the.
Yes.
employees who agreed to get their annual increment between February to June during 2006 in the pre-revised pay scale as one-time measure.
Yes, we cannot go into that.
There, one increment was granted, thereafter this 16860 was revised by granting one increment, and finally it came to below.
Or not only one increment plus next increment in the revised pay structure on 1/7/2006. Don't read half.
Basically, including dimension increment, if any, so and so.
So ultimately it is the last row.
Yes.
Let us make it simple. Last row 17,220. This is all these are in revised scale, right?
So this.
All these are in revised scale. Central his LPC by page this page 46. This is the first time, right? But after that they have omitted to calculate something, and later on also central government has given. Then this Central Civil Services revision of pay rules 2008 has been finalized, right? Ultimately, in 2012, central government has realized that he was entitled for a pay of rupees, pay or whatever, 17,220. This is the basis. And all this repetition is after that.
It did stand corrected on one point, by considering the records, I returned it. His last pay was of 2009, and thereafter, he joined the Guwahati High Court. So his pay fixation will be based on this 2009 last pay drawn. I'm coming to it. Now, if thereafter central government grants some increments or his pay is increases, this page 58, then he'll be entitled to area amount. He'll be entitled to the area amount from the central government. I'm not, I'll just cross-check this aspect with the records, my lord. I found there in the records because I have a small noting here.
No, he'll be entitled. But okay, but
His pay fixation will be on the 16860.
no, he is cannot be.
I'll try to satisfy.
No. 70,220. If all this, see, I have previously told you, all these central government are faster, state governments are slower. So far as revision of pay scale. If you argue on that, also you can argue. This is an admitted position.
No.
Central government has come up with the revision of pay in the year 2008. And the state government has come up with the revision of pay in 2010. This is also an admitted position. As per central government revision of pay rules, and we are not with the areas. Don't bring areas. We are not concerned. He is not asking for areas from the central government. Why we'll go into that? We are into his last pay certificate. Initially paid by 46, it was that. Then subsequently by page 48, they have realized that this is his last pay. Now, question I have asked you repeatedly that page 48, this 11,825 of the state government scale was in the revised scale or so? When my question is, because I am not an expert like you in pay protection cases. If state government has come up with revision of pay scales in 2010, why you have not correlated his revised pay scale in the central government with the revised pay scale of the state government? Because all these issues you are double benefit, you are asking, questioning is why? Because you initially fixed it in pre-revised, then when revision of pay came, you again fixed it. I am asking you, why not? Why not the revision of pay, revised pay of the central government should be correlated with the revised pay of the state government?
One reason Lordship has understood that at that point of time, the ROP rule did not came.
When it came,
So, when he was, transformed from CBI to.
and this is merely, this is not an office order,
Yes.
page 48.
So,
It is like no kind of order.
noting.
Noting does not have any value.
Lord, I'll be able to satisfy your Lordship with regard to case 48 and case 58 also. Your Lordship's query that why 17,220 has not been taken as his last pay. Perhaps, if I have understood.
Yes, when this has come to the notice, it should have been taken cognizance of. I am asking you that. It should have been taken cognizance of, and by that time, Assam revision of pay rules have come into force. Why not you correlate his revised pay scale in the state government, central government, with the revised pay scale of the state government? Because all these state government rules are also framed taking cue from the central government. All this you are saying zigzag, that double benefit, all these are double benefit because pre-revised, then again you fixed it in revised.
Because of the ROP rule in the central government came early, he already got the benefit of revision of pay, and thereafter his.
Revision, I have said.
Again, he was given the highest of the pay scale.
No, it is. Are you disputing? Are you disputing in this page 48 that he should be, his pay should be projected in the highest of the pay scale? That was not in dispute.
It's corrected. This 11,825 thing was corrected by the impugn order.
Why? After giving my side of view, tentative view, tell me on which basis? Which is the impugn order? I don't know.
Annex, annexure 20.
Page 80.
Page 80. 80 and 88. 104. 78 and 80. The page 104. It starts and relevant.
Let us read page 79 also.
79. The fixation of pay in respect of this also, which refers to the subject side of the law and directly to the observation made by the finance department in connection with the fixation of pay in respect of this also. Finance department observed that the last pay of 16,860 PPB 12,660 plus debt pay 4,200 drawn in the sum of post under 6th pay commission of Government of India may be protected and fixed at a stage of pay of rupees 19,070. That is 13,170 plus debt pay of rupees 5,900 of the new post in the scale of 10,000 to 40,000 with gateway of 5900, i.e. under 6-pay commission of Government of Assam on his appointment joining as stenographer grade 1 in the office of the Registrar General Guwahati High Court, Guwahati, effective from 9/1/2009, with date of increment on 1/7/2010. That was revision of rules 11 and account service allocated in 2010, where we accord 22/1A1, subject to the conditions that imposed.
Okay, stop. Now, this finance department opinion, quote unquote part, should not have been read like this. Finance department observed that the last pay of rupees 17,220 drawn in the former post of 6-pay commission of Government of India may be protected and fixed at the stage of pay of whatever 19,000 should be changed accordingly. I am taking cue from the finance department and I am putting the query.
That page 58, I will clarify. Lordship's query, I will clarify. Why it is not 17?
Yes, finance department was, we proceeded on the basis that finance department,
Lordship can also have a look at page 1050.
where is finance department?
Some equal page.
Right, we just made an exercise, tentative exercise. Page 105.
Same thing has been said.
Same thing.
Finance departments.
Yes. And this is the only region, ultimately.
Yes.
Now tell me your side of the story regarding why 17 to 20 is not applicable.
Take the record. I have some memory, my lord. I have seen some.
Otherwise, if you fail to explain that why 17 to 20 should not be applicable,
Definitely explain.
Ah.
I'll definitely.
otherwise don't go into all this maze. I'm making it simple.
Things, the factual aspect is absolutely clear with your lordship. Lordship has already understood. my lord. That's 68.
I have not understood anything, but I have gone to the
The root of that.
core. I am not going into all these explanations.
It's not because.
Writing letters is the best part of the administrative authorities. But question is, if a person has been enjoying or has been made to enjoy a particular pay in the revised scale in the central government with the technical resignation and pay protection not in dispute, why not that pay should be correlated with the revised pay of the state government? Technical resignation plus pay protection, those two issues are not in dispute, right? We are not required to deliberate on it. Now, a person is made to receive a particular pay by the central government in the revised scale. No doubt. Then the issue is why that pay in the central government should not be translated and correlated to the revised appropriate stage in the revised pay of the state government. His pay should not be below. Pay protection means minimum should be protected. If the same pay scale, whether in revision of pay rules 2010, that scale is available 9,300 to 34,800, show us. You go through all this fitment table and tell us on the next day. All right? This is sum and substance of the story. I'll not go despite if you try to make it go through this, I'll not go. Yes, Mr. Talukdar. Yes, finance. This is your side of the story. I am asking you why 17,220. Yes, Mr. Nair, anything to say?
But,
17,220
that-
will decide all the issue, and whether you were given extra or not will depend upon it.
Right.
If it's corresponding 17,220 and in the revised pay scale of the state government, you are with the pay protection are fitted into the appropriate stage. And thereafter calculation is to be made.
that was not done.
105 is clear. Finance department is of the view that
Even their affidavit,
16,860.
might,
Why not 17,220?
they have not done that.
I think that is the issue.
On top of that, there is another issue.
What issue?
My lord, that when I had joined in the High Court, I was given a particular offer in the pay, irrespective of the previous revision in the central government. I accepted that and came.
What offer?
My lord, that 11, the highest of the pay scale in the state government, irrespective of whether the revision took place or did not take place. Because as on that date, my lord, there was no revision.
No, it is now, where is your appointment order?
My lord, excuse me,
Appointment order.
my lord. My lord, page 41, my lord.
Is there anything regarding pay?
My lord, only the scale is mentioned at 11,825. Page
This is only
41,
is mentioned.
my lord. Only
There is nothing office order. This
No.
is 48 is noting only.
yes, my lord. My lord.
Noting
that
only.
Particular,
Simply what I understood is that, he was given the highest of the pay scale 11,825. That should not have been given. That was corrected after the finance department observation. That is the thing.
But there is no
There is nothing that.
from his side. There is nothing from his side.
That Lordship will consider, but error has to be corrected.
Error is to be corrected.
So
Now,
that is-
No, first tell me that what is the corresponding grade? That is the issue.
that thing-
Whatever discretion are used by all these authorities. First and foremost, what is the law? And what is the concept of pay protection and technical education? We are not in doubt that what kind of pay protection he is entitled.
Constitution had happened and how it should have been happened.
It should have been happened. That is only that, and my tentative view is that revise after revised pay scale, there is no doubt he was finally by page 58 or page 48, whatever. He should be correspondingly fitted in the at the appropriate stage of the state government revised pay. That is what is not there, hidden. We are not into it. Mr. Iyer,
my lord.
express, okay, recorded, okay, but not recorded that you were given assurance, all these are not
My lord,
going to be fruitful.
my lord. I understand. I understand.
Yes, Mr. Talukdar, you are the accountant general or what?
I'm not accountant general, I'm the council of the accountant.
Huh? Council? Also, anyway, same thing.
But in this case, Lordship,
No, you'll be better equipped to address on this issue.
that Lordship, but in this case, Lordship,
See, this petition, I don't know, since pending since last 10 years. And this side, we find very difficult to all this calculation and pay protection. I think that is the reason perhaps.
Did not happen, because there is.
Whatever did not happen, should have happened. But that is why I am asking you, what should have happened?
As simplified.
As simplified.
Try to- as simplified.
If you want to take me into the maze, I am not going into the maze.
Not because- possibly-
I am Mr. Talukdar, I am Mr. Finance. Where is that finance? Yes. 1680, 16,860 or 17,220, and what is the proper scale? Because they will be knowing. If it is 17,220, exercise should be left to them. There could be another round of litigation. That is a different matter. But if it is 17,220, as per 105, then it should be redone.
That is not his case. 17,220 is not his case, perhaps.
My lord, in fact, I have brought it on record, man.
Hmm?
I have brought it on record that 17,220. I have brought. it
All
on
these are, this is not going to happen then.
Fine, my lord.
All these prayers are not going to happen. Hidden assurance we are not,
No, that's
will
17.
not take cognizance of.
That's 17. I myself have brought it on record. Man.
Yes. So what should be the law? That is all. We are not concerned with his prayers.
Yeah.
Ultimately, what relief, if he is entitled to any relief, what kind of relief he is entitled to? That is the core issue.
Man.
So it is 17,220 or not? This is all. Yes, Mr. Finance, what was the prayer Mr. Counsel has said? No, if you continue, then we have done an exercise. You are the counsel for the finance. Okay.
Ma-
So we have,
My lord, I understand. In the box, my lord.
yes, within four corners, this is the issue.
Right.
Ultimately, it is the origin. When you shifted to High Court,
Right.
what kind of pay protection you are entitled to as per the law. That is all. All these calculations we are not going to do.
My
Only the pay scales we will do.
Right.
We will not go and calculate. And whatever area or whatever amount you are to be refunded or you should be protected, that will follow consequentially.
Right.
So basically, all these are issues are within this part. You just address on it.
man.
Otherwise, it will be difficult to decide. He is still in service?
Yes, madam.
Okay, when Mr. Borpujari? আমার পিঠে কিন্তু পিস করে আছে সিরিজের কাজ না কি রাখি তো 26 জীবন হয়নি না 29 মঞ্জুটু কবর হবো অনেকের ঠিক ও 7-11?
7-11.
7-11?
Would it be after some?
Then it will be Mr. Nair.
On the next Thursday, my lord, if possible.
14 is not possible then. 19.
19.
19. Okay, Mr. P.D. Nair, for the petitioner. H. Sharma, additional senior government, 1, 3, and 6. H.K. Das, line standing counsel. Guwahati High Court for the respondent number 2, 4, and 8. And Mr. A. Cholia, learned counsel representing Mr. R. Borpujari, learned standing counsel finance department for the respondent of 5 are present. Mr. Cholia has submitted that Mr. Borpujari is indisposed. Okay, Mr. Borpujari, standing counsel, finance department, is on medical leave. Is on leave on medical ground, and has thus paid for listing of the case on another date, full stop, as sought for by the learned council by the parties, lays the case on 19,
19. My,
11.
my. Deeply.
High Court.
My lord, not exactly
High
the
Court?
High Court, my lord. It's
Huh?
not exactly a High Court matter. This is regarding the MSCT, my lord, in the post of a
MSCP.
copyist in the tribunal.
Hmm?
The post of copyist in one of the tribunals,
Even.
where there is an observation from the registry of this honorable court, therefore. the High Court has- Well, what had happened is this person, the petitioner, was serving on stopgap arrangements in the tribunal for quite a long duration.
No, what other side, Mr. Andy, Finance, S. Sharma. You represent judicial department.
Yes, he is coming.
And where is finance?
Finance is, my lord, a party pro forma, my lord, they would not have much to do in the matter.
Hmm?
They would not have much to do in the matter. It would be
Okay.
mainly the respondent number 6 who has to. Cutting a lot, long story short, my lord, in the year 2004, the petitioner.
Let
was-
Sharma come. What is the prayer here?
That I should have been called for their rejecting my candidature for the Viva Fosse was wrong. And that I should have been called and I should be called. my lord.
Oh, you are not an employee.
I'm not an
Oh, I thought that you were an
No, no,
employee.
I am. I vie for the post of copyist in the tribunal.
Okay, okay.
Lordship should find the prayer.
Yes, Mr. Mohanto, you are waiting for which one?
We look.
Petitioner council is available. Yes, tell me then. Let us.
The history, my lord, of the leading to this case will be traceable at page 43, an order of this honorable court. my lord.
Page 43.
Starts at page 42. When he first approached this honorable court in the year
Okay, okay.
2012.
Let me read.
Page 43, I'm reading, my lord. Miss So-and-so learned counsel for the petitioner, Mr. So-and-so learned standing counsel appearing for the GHC, so-and-so learned standing counsel appearing for the finance department, and so-and-so appearing for the state of Assam. The petitioner, having passed the higher secondary examination and vocational course, he was engaged by the office of the District and Sessions Judge Nalbari as copyist temporarily in 2004 in a fixed pay of rupees so-and-so. Since then, he has been continuing in that post without break till now. The office of the District and Session Judge Nalbari extended the service of the petitioner from time to time. The condition of engagement is that in the event of creation of a new post, the petitioner would not claim for regular appointment on the said post unless he appeared before the selection committee. The service of the petitioner was subsequently placed in the newly created office of the presiding officer member MSCT Nalbari in 2011. The petitioner, together with equal-minded employees of the district and session judge, in the meantime requested the respondent authorities to regularize their services against the sanctioned post in the establishment of the newly created office of the presiding officer member MSCT Nalbari. It is thus clear that the services of the petitioner have not been regularized till now. In the meantime, much before his confirmation, the respondent authorities issued the advertisement dated 13/12/2012, inviting application from the intending candidates for filling up one post of copies through direct recruitment, which in effect set at naught his right to regularization to the post he had been holding for the last almost 10 years. Aggrieved by that, he has filed this petition for appropriate relief. In the affidavit in opposition filed by the respondent number 4, that is the presiding officer member MSCT Nalbari, provided subpara of para 7 has made the following averment. The board shall hold a written test as well as viva voce for selecting the best and most suitable, and all the candidates who appear there, including the petitioner, shall be duly considered. It is necessary to mention here that as per the terms of advertisement, due weightage shall be given to the candidates having experience in judicial works as working in judicial institutions of Assam. It may be stated that the aforesaid averments are consistent with the terms and conditions of the advertisement, which says that candidates having experience in judicial works or working in judicial establishment of the Assam with requisite qualifications shall be given weightage. The learned counsel for the petitioner is apprehending that the experience of the petitioner may not be taken into account by the respondent number 4 by the selection committee while considering his case in the ongoing selection process. In our opinion, the statements made by the respondent number 4 in the paragraph extracted above have removed any apprehension entertained by the petitioner. The apprehension entered by petition is clearly misconceived. Consequently, the writ petition does not survive for consideration. Resultantly, the writ petition stands disposed of by directing the respondent number 4 to give due weightage to the experience of the petitioner while considering his case in the ongoing selection proceedings. Hereafter, my lord, when I was not called for the viva voce, I made certain inquiries and then I found at page 45 on a supposed query made by the presiding officers, the selection board, page 45, the Register Administration of this Honorable Court says, in inviting a reference to the subject and letter cited above, I am directed to inform you that as regards the selection of copyist, question of giving due weightage will arise only if the candidate qualifies in the written test. Since the candidate has failed to qualify the written test, question of giving due weightage does not arise. As regards the selection of so-and-so, this is not one of the first paragraphs. And therefore, my lord, at page 46, the candidates were called for the viva voce. And it is at that point of time, I approached this Honorable Court after filing a representation. My lordship has the order dated 12/8/2015 passed by this Honorable Court in this particular writ petition, where this Honorable Court directed that the viva voce may be held, but the results will not be declared. Order dated 12/8/15.
12/8/15.
15. Thereafter, in 2018, it was modified.
12/8/2015.
First order. The last paragraph I'm reading here. After hearing the learned counsel for the parties and perusal of the materials on record, it is hereby directed that the viva voce scheduled on 13/8/15 for the post of copyist in the establishment of member MSCT Nalbari may be held, but final results shall not be declared. And this remained continued, my lord. Then lordship would have the order passed on 8/1/2018, where it was modified. The last paragraph, my lord. Considering the fact that the petitioner has failed to qualify the written test, the authorities are permitted to publish the result of the viva voce and make appointment of the best merited candidate, but appointment is made subject to the result of this case. This is how it stands today, my lord. Now, in their affidavit in opposition, the true facts have come up. If lordship would have their affidavit in opposition, I will directly come to the annexures, my lord, which starts at page 6 of the affidavit in opposition, filed by respondent number 6.
Now, thereafter, appointments were made or not?
Appointments were made.
Have we
The
made
results
them
were
party?
But that has not been done today.
Then,
since
whether it would survive.
It would survive because my lord, the appointment is already, the only selection of appointment made is already subject to the outcome of the writ petition.
So, but without hearing him, how can we?
But if any appointment which has been made is already subject to the
But
outcome of
that
this
is
writ
not the
petition.
case, but subject to the outcome, but he should be given the opportunity.
In my humble submission, my lord, he would have been a necessary party in case.
Because at that stage, when you were aware at the time, because you are annexed, you have annexed.
I am only aware to the extent that this honorable court allowed them.
No,
allowed
6
them
of them qualified in the written test.
in the written test, yes.
And you did not make any of them parties.
Because my only claim was that I should have been allowed to participate in the Viva. My claim is not that they were wrongly allowed to participate. I do not have a grievance against them. It is only if I am better than them that I stand a chance.
Where is the advertisement?
Lordship will have the advertisement.
39.
It's page 39. Page 39. Should I read it? The bullet part is necessary. Applicants, those who are already in service, should submit their applications to proper channel. Applicants for the post of LDS stenographer and copies whose applications are found in order will be called for written test examination to be held at a place and the date to be time to be notified later on. The qualifying candidates and written test will be further called for viva voce computer speed test as applicable for the post. The applicants for the post of peon from Chopila not necessary. Next, candidates having experience in judicial works or working in the judicial establishment in Assam with requisite qualification as stated above shall be given due weightage. The rest time I don't not necessary. Now here two.
Now, affidavit, you want to say it?
Ma'am.
Affidavit.
Worship would have page 6 of the affidavit, which they say is the resolution of the meeting held on. Now this lordship would have the date, my lord. 18/5/2013 is the date of the first meeting. Here, my lord, at the second paragraph, an advertisement was made for the post of copyist LDA and the MSCT Nalbari.
When the written test was held?
My lord,
Written test was held when?
written test was held thereafter. My lord, written test was held on 13/7/2013.
13/7.
2013. After this resolution. May I read the resolution? An advertisement was made with the post of copyist LD and the MSCT Nalbari accordingly received as many as total.
Which paragraph you are reading?
My lord, page 6 of the affidavit, second paragraph, and advertisement.
Page 6 of the affidavit.
Affidavit in opposition. Annexure A.
Of respond number?
6, my lord. Only one affidavit
Six.
I have at home.
Paragraph
Not paragraph, my lord, the annexure part, the resolution. which
or
they have annexed.
resolution? Okay.
The second paragraph, and advertisement. An advertisement was made for the post of copyist LDA in the MSCT Nalbari accordingly received as many as total 114 number of applications submitted by the different candidates for filling up the post of copyist. Said applications were scrutinized by the board and as many as 103 number of applications were provisionally accepted. So far as the post of LD is concerned, MSCT Nalbari received as many as 154 applications submitted by the different candidates for filling up the post of LD assistant. The said applications were scrutinized by this board and as many as 146 applications were provisionally accepted. The board discussed the process of recruitment of the post of copyist and LD assistant, and it was unanimously decided that written examination, computer proficiency test, and viva voce will be held for selection of copyist and LD assistant. Board also discussed the marks for written test, computer proficiency test, and viva voce and accordingly fixed as follows. English 100, general knowledge 50, official language 50. So it was a 200 marks. Written test was there. Next page, my lord. The meeting further fixed the date of written examination. Accordingly, the date has been fixed for written examination on 13/7/13 from 10 a.m. for the post of LD and from 1 p.m. to 3 p.m. for the post of copyist, and discussion on issuance of call letters to all eligible candidates was also made. Meeting also discussed about the preparation of the written test. Accordingly, the board authorized chairman to prepare the question paper of written test. So far as computer proficiency test and viva voce are concerned, same will be decided on the date of interview. The resolutions, my lord. It is resolved the written test will be held from 13/7/2013. The second resolution is it is also resolved to issue call letters by post to candidates who have the required qualification. Third, it is resolved to authorize chairman of the selection board to prepare question paper. Fourth, so far as Viva Voce and computer proficiency test is concerned, the same will be decided at the time of interview. Candidates only who qualified in written examination will call for Viva Voce and computer proficiency test. Now, computer proficiency test being held in 2013. The next page, annexure B, is a resolution of 2015. The first resolution is not important for us, madam. Lordship would have the at page 9, resolution number 2. In this selection board meeting, while discussing the appointment procedure for the vacant post of copyist in the office of MSCT, Nalbari, it has come to a notice that on 13/12/11, an advertisement was made for filling up one number of posts of copyist along with 2 posts of LDA, 1 post of stenographer, 2 posts of peon and chokidar. Accordingly, a written test was conducted and cutoff was decided as 50% for copyist. Mala, this cutoff decision was not made as on 2013. There were only 2 meetings held, one in 13, one in 15. So now after the results, it is now being decided by the board that we will take up 50% as the cutoff. Accordingly, a written test was conducted and a cutoff mark was decided as 50% for copies. 7 numbers of candidates qualified the written test and they were selected for Viva Voce. But the petitioner so-and-so who is working temporarily as copies in 2004 in MSCT had filed a writ petition number so-and-so before the Honorable Court for consideration of his appointment. The Honorable Guwahati High Court vide order dated 23/9/13 dispose of the said writ petition directing the respondent number 4, that is presiding officer, to give weightage to the experience of the petitioner while considering his case in the ongoing selection proceeding. While considering the procedure for conducting the Viva Voce of the post of office, a confusion has arisen as to giving weightage to the experience of the petitioner, as the petitioner could not qualify the written test, therefore failed to qualify the Viva Voce examination. So selection board has come to an opinion that a clarification direction might be sought. That is the clarification which I had read in my writ petition. I had given that clarification which is given by the registrar at page, Lordship would find, this was the clarification given by the registrar of this honorable court at page 45 of the writ petition, where he said that the question of a weightage would only come in if the person qualified the written examination. Page 45, in inviting a reference to subject and letter cited above, I am directed to inform you that as regards the selection of copies, question of giving weightage will arise only if a candidate qualifies the written test.
What is your primary ground?
My lord, firstly, that 50% cutoff which has been decided is after the marks of all the candidates were known.
Then some right has been crystallized
My lord, two,
in respect of the person who has been appointed.
no, my lord. He has scored more than 50%. So
No,
he
no.
would be there all the time.
Now,
He
if
was the
suppose
highest
your
scored person.
repetition is allowed,
My
even after passing of this 8/1/2018 is concerned, some person's appointment is going to be cancelled.
Yes, which was subject
Then
to outcome
which
of the
is-
result of the repetition, my lord. Which was
Yes,
already
but-
made consciously out subject to outcome. of the
Yes,
result
but
of
it
the-
is also required to be implemented then if appointment has been
That,
made.
in my humble submission, my lord.
Because
that
after subsequent development, if
At-
somebody has been appointed,
at best,
show me any law.
at best, he would be a proper party. He will not be a necessary party, my lord. But
No, no,
necessary
no, no,
party
no,
is
no.
only that person.
No, no, no. I cannot agree unless you show me some authority. Otherwise, I don't think
That
it is.
authority, yes, I can show that authority.
Show
which shows
that
if-
authority that otherwise, if right has been crystallized
that
to an
is-
extent,
That is what I'm trying to say, Bimala, that right has not
that
been
because
crystallized.
at that point of time,
Yes.
the authorities are permitted to publish the result of the Bhagavasi and to make appointment. It is not known to who is going to be appointed.
But all
Best
that,
merited candidate.
all that has been kept subject to outcome of the writ petition,
No.
meaning that if the writ petition stands allowed,
Show me any law in this situation.
that he is at best a proper party, not a necessary party.
He is a necessary party to my view.
Well, I'll place a division.
Unless a
But obviously,
person's appointment is likely to be affected.
in a selection process, my lord, when-
Absolutely.
I'll bring that
Because
up.
at that time may not be.
My lord,
But after a stage,
yes,
written test, whether 50% cutoff mark is decided or not, that will be subject to record at the after the game has begun.
yes,
But question is that your interim order has been modified.
modified to the
And
extent,
at the time of passing the order, the person was not identified.
yes.
Then after an appointment, somebody has been
That-
appointed.
That someone has been appointed has not come on record from their side. Is
No,
not. on
it is
record
you
from my
who
side.
has to stand on your own feet.
Well, I would have done that in my humble submission. I would have done that had that subject to outcome of repetition does not.
No, no, no,
Number one,
it's
number
subject
two,
to the outcome. That does not mean. Then you're will be non-general party.
She will give me one opportunity to show that it is actually a case. of
Even if
a
your
proper
case
party.
might have some merit on the basis of 50% cutoff mark fixed at a later stage.
Hmm.
But because of non-general parties, your case will fall.
But, if I can show that it is a proper party and not a necessary party, then my case would stand. This is a matter of 2015.
After this order, your repetition also survives on that point. Best merited candidate,
Yes,
somebody has been appointed.
no, best merited candidate would be
If
if
somebody has been appointed, this order is 2008, 6 years.
in case
Somebody has been appointed.
in case, my lord, in case in the selection process I was unduly kept out of the fray, and
That we do
now
not know.
it is only
As
when-
on that, that is your contention.
yes. In case this honorable court finds that I was unduly kept out of the fray and I should have been allowed. to
Your
participate,
only
and then I get more
only
marks.
thing of survival is that 50% cutoff mark fixation. Otherwise, so far weightage is concerned, that is a different issue.
Weightage, madam, what the respondents in my humble submission has done is confused preference with weightage. Confuse the term preference with the term
Yes.
weightage.
Now, what is the concept of weightage?
Weightage is when, my lord, the total marks will already carry a weight in itself. A preference is when among the two standing equals.
What
one
is
has
the
to give
concept
an-
of weightage?
Weightage is
At what stage?
at what stage?
At
It
what
has to be, it has to be,
In a written test also.
the weightage, it has to come as an overall. It has to be taken in the overall markings. And when I'm stopped at a level where I don't go to the overall markings, the question of weightage will never be there. I was stopped midway.
Overall mark, no, so far fixation of cutoff mark, it is within the discretion of the selection authority.
Hmm.
But at what point of time, that is the issue.
That is one.
That is the issue. Otherwise, it is discretion. If there is no set marks in the rules,
Rules.
Rules,
It is only the.
it is silent,
It is only.
then
the
before the game is before the game is
It
begun,
has to be determined.
it is to be determined
Determined.
otherwise.
And even
But
otherwise,
otherwise, it is within the discretion.
even
At
other.
what point it was determined, that we have to examine, subject to what
the-
will come from the respondent side about fixation of 50% in the written test. Otherwise, screening is permissible. Otherwise, you have
screening
to
at
weed
what
out
point? Yes.
all these
Screening-
undeserving candidates. One post, yes,
We
it
cannot
should be
have 1,000
limited
we can-
up
we
to
will
some
not have-
stage. But question is regarding weightage,
Weightage.
that at what stage?
At what stage?
Because division bench has simply said, nothing more.
The weightage is to be given. and
Weightage is
the
to be,
advertisement
weightage,
also
what
says
is the
that weightage-
observation? What is the observation? Weightage? Division bench.
44, my lord.
Weightage to the experience.
Experience of the petition.
Now,
So
weightage
that
to the
has-
experience,
So that has to.
how
come-
it is to be interpreted.
My interpretation will be where others start at zero, people having experience would start at a higher marks.
And
That
block,
is- And block.
and block.
Anybody who has an experience will get a plus mark. He starts with a plus mark.
Show me some concept
Other-
of
other-
weightage,
other-
show me some concept of how
The weightage has to. come.
authority, yes?
Weightage authority I'll try to bring in, and the other part is
Where is that?
whether it's a.
Any authority?
Madam, as of now, that weightage part, that the weightage has to be given is with me. But how it is to be applied.
How it is to be applied?
I'll bring it.
We are into how it is to be applied.
What I was trying to draw a difference was between a preference and a weightage.
Okay, the preference concept is quite clear, ceteris paribus,
Yes. Then
other things being equal.
other things. being equal,
Okay,
it's only-
now what is weightage?
So now here, if they try to say that it is at the end of the selection, we'll try to go for a weightage, it becomes a preference.
That might be one way of interpretation.
And
What
if-
way, what is the
and
other way of
If it
interpretation?
is a weightage, now
What is your way of interpretation?
all
Show
my
me some
certi-
authority.
when all my certificates I have already, if I have this certificate, I get a +3, +4, +5. It has to start with that.
Whether
Other-
this kind of weightage is to be at the stage of written examination.
Hmm.
If it does not have the minimum question of fixation.
That,
is
I
another
understand,
point.
I understand.
But
Barring that,
whether it can be read into the written examination,
or whether it comes up
it
before the
may
written
come at
examination,
the
we
stage
start
of
with something.
viva.
If Viva is something which I know now or not, how will I answer a question? What is my demeanor in a interview?
But I'm not very satisfied
my
as
own-
regards non-joinder of parties.
I'll try to bring in the part that matter where it will be the case of a proper party and not a necessary
The
party. to-
question is after appointment, he has substantive right to be heard. Because this has been made clear, subject to the outcome. Yes, his appointment order might have a statement that your appointment will be subject to the outcome, the
Yes.
writ petition.
Yes,
But that does not mean he should be deprived of an opportunity of being heard.
of being heard on which point, my lord?
Yes, all these
On
points.
which issue?
On all issues.
On an issue whether I should have.
On all issues, why he should not be, his appointment should not be cancelled.
It will only be done so if I score over him in merit. Prior
Not-
to that, he remains a proper.
Not satisfied about your explanation
I'll-
regarding non-joiner of parties.
I'll try to bring in my lord.
Because, yes, MS Sharma, you get the appointment of this particular person who has been appointed, we don't know, Mr. X. Mr. X. There were 6. As it has been submitted that one of them has been appointed. And who is that Mr. X?
This is. There is no statement to the effect who has been appointed.
There is a positive direction of the division means give weightage to your experience. But experience can be read into the written test or not, that is an issue.
It can be apart from the written examination, but has to start when the selection starts. I start with some positive marks.
It cannot be perhaps subject to your,
Because if we take it stage wise,
what is that called?
someone starts with a 0, I start with a positive point is what I'm trying to impress. Because
What
I
is
have
that?
experience.
Running before the,
Gunshot.
jumping the gun.
Yeah.
It cannot be jumping the gun.
That experience part would be more. Because it
Perhaps
is something that others don't have.
subject to your submission,
No,
but
I'll try to
it cannot be like jumping the gun. That before the race began, you have started with an advantage.
That is what is,
That game is not played.
that is what the weightage part could be.
That weightage that is like to jumping the gun, that you start with an advantage, unlike preference.
And,
I don't think
and
it is almost
if we go. by
almost
the-
not exactly similar, but almost similar to the concept of preference.
My lord, if we go by what the respondents
So
are
what
saying,
what
a
is,
person
show
with a-
me any weightage,
I'll-
any weightage interpretation of
I'll
weightage.
I'll have to bring it, whether it starts with the.
It is 9 years
Or she will give me a week. This is a question, my lord, which I was not prepared for. A week.
because I have not been taking up any service matters for nine years, or 5 years.
And
So I have lost contact with all the concepts. But so far preference is concerned, yes. It is at the end.
Preference is always at the end, but the advantage of a
Ah,
weightage.
so but
to a particular
weight is
extra-
as you have submitted that it is will be like jumping a gun with an advantage.
Yes.
Before the gun is blown to start the race, you have already started with an advantage. That concept is not
That is the concept of a weightage.
flowing
I
with the
bring-
service jurisprudence.
I'll bring in the judgment because yes, it is not, it would not appear fair because I start at 2 steps ahead. But that
Yes.
2 steps ahead is because I have an experience which the others do not have. And unless that is given, the weightage goes. The concept of a weightage will go. I would not be having a weight,
But and secondly, non-joinder.
non-gender. These 2 things I'll clarify.
Because if that party is not, and it is clearly will be another litigation. And leave will be granted. Again, proceeding will be protracted. And by that time, you will be overrated.
I'll
How
have-
much age?
I'll have my instructions also whether he can make them a party. I'll have an instruction on that.
Okay. Adjudicatory. কেটে দিল ফিক্স করে দিল না কিছু না Fix করে। হুম? কেটে কেটে দিব ভাই পক নহলে ফিক্স করব 12 11 okay. R. Majumdar, Learned Counsel for a Petitioner, S. Sharma, Learned Standing Counsel, GHC are present. On the prayer of Mr. Majumdar, Learned Counsel for a Petition, is the case on 19 or 12, no? 12 11. What are these judgments? There are set of judgments. Post of physical challenge. Yes, Mr. M.S. Sharma, whether it is permissible to fix cutoff mark after the game has begun.
That, my lord, is,
He will be saying it is not permissible.
that, my lord,
Huh?
is debatable.
Debatable will not do. Debatable if there are, I think there will be maximum judgments in service jurisprudence, right?
There are.
Cannot change the rules.
No, question is whether it is permissible. There are conflicting judgments also.
There.
What has happened that in that case that refer to the larger bench after that judgment by 3 judges bench, it has been referred to some constitutional bench or something that whether the rule can be changed after the game has begun.
That issue and this issue would be a little bit different.
No,
But
what is the outcome of that? I'm not.
that outcome I have.
I think that has been decided. I know that 3 judges bench and consisting of Honorable Justice Salamet sir has sent it to the larger bench and I forgot the name of the case that whether it is permissible to fix the rule of the game after the game has begun. Because there were conflicting judgments. No, your question of regarding 50%
Yes,
is hinges on that.
to a large extent also.
To a large extent.
Also the power.
If the
to-
constitution bench has settled or larger bench has settled,
Then it can
that
be
is,
done.
that will be the law. Because Justice Salamet sir in that judgment has said that there are conflicting judgments on the issue. So it was sent to larger bench.
We try to find out that, but
Huh.
I understood.
It was sent.
Last time what I understood was applying that law.
It was
to
definitely
particular-
before 2017.
14.
13, if I am not wrong.
What was difficult was.
No,
applying it
thereafter
to
we'll
particular
see the
situations.
facts. Thereafter we'll see the facts, but what is the law?
I'll get that also. if it
Right.
is there.
That is one. Second one is weightage. Third one is
Party.
party.
Three of them.
These three issues.
The fairness aspect would be infringed upon if he
What
like
fairness?
has fallen from this honorable court, that you begin the race before the
And that weightage concept
Then
is
I'll
a
get
state,
the
it is
weightage and
different
then-
from preference. Let us see.
It is different.
We are clear about preference.
Preference, there is no doubt about it. But weightage, when does it start?
Whether it is at every stage of the competition.
Or whether it would be one complete mark, which would take them ahead of the other participants and allow them to start at a.
Because
Ahead
in
point.
some cases, weightage, if I remember correctly, it is a component of the interview marks.
It can be kept as a component of the interview.
Yes.
It can be,
It can be.
but would it always be? Even in my case, if it is to be a part of the.
Show me
interview-
the exception.
I'll do. I'll do that. Oblige.
Item number 11.
Madan Kumar. Yes.
The petitioners herein are inmates lodged in the central jail.
Hmm? Hmm?
The petitioners herein are lordship inmates lodged in the central jail lordship. They have come against an order of the learned Chief Judicial Magistrate Amin Gao, whereby the lordship, learned CJM has in its administrative capacity has banned the consumption and sale of betel nut and betel leaves in the jail premise. Lordship, my case is that the CJM in its administrative capacity does not have the power. The CJM only can suggest to the inspector of prisons if any changes needs to be done in the jail premises. That is the whole case. Lordship, if I may take your lordship to rule 19.
One. What is petitioners?
Petitioners are lordship inmates, lordship, the convicts. Most of them are serving life imprisonment. Lordship.
Where is the impugned order?
The impugned order is at page 35 of the petition. This was passed, lordship, subsequent to an oral order, and we submitted representation.
Hmm?
And lordship, the CJM initially, lordship, gave an oral order. Basing on that, lordship, inmates even submitted a representation before the district and sessions judge. The district and sessions judge referred the matter back to the CJM, and this order was passed eventually.
Which order? Page?
Page 35 is the order, lordship, which is under challenge.
Yes. Yes,
Lordship may kindly come to page 14, Lordship.
page 40.
14 of the petition, Lordship, the rule 19. Okay, Rule 19 of the Superintendent and Management of Jails in Assam.
Mm-hmm. Page
Page 14, Lordship.
14,
14,
1/4.
1/4, Lordship. May I read, Lordship?
Yes.
Rule 19, ex officio visitors. The chief engineer, the director of public instruction, the inspector general of police, the director of public health, the director of agriculture, and the director of industries shall be ex officio visitors of the jails in the state. Commissioners of divisions and district and sessions judge shall be ex officio visitors of all jails within their respective divisions and circuits. The civil surgeon, so and so, Lordship is not relevant. Lordship, Rule 20 is relevant in this case, Lordship. Appointment Board of Non-Official Visitors. Board of Visitors shall be appointed by government of all jails. These boards of visitors shall, in the case of jails at district headquarters, consist of the district magistrate as chairman, the chief judicial magistrate, and 4 non-official members. And in the case of jails at subdivisional headquarters, the subdivisional officer who will be the chairman, the subdivisional judicial magistrate, and 2 non-official members. The constitution of the boards showing the designations of the government officers in the boards and the names of the other visitors and any changes in the visitors that may be made from time to time shall be published in the government in part 1 of the census. Members of the boards other than government officers shall be appointed for 2 years and shall be eligible for reappointment. Lordship, the CJM hearing is the non-official member, Lordship, is the board of visitors, Lordship.
Hmm?
The CJM, Lordship, by Rule 20, Lordship, the CJM is a non-official visitor, Lordship, in the board of visitors. So his role is explained in Rule 21, Lordship.
Yes.
The board of visitors shall pay a joint visit of inspection to the jail every quarter.
1 minute. Who is the board of visitors then?
Lordship, board of visitors also consists of the CJM, Lordship. There are others also.
Hmm. Board of visitors shall be appointed by the government for all jails. It is extracted from where?
Lordship, Lordship, it is extracted from Lordship jail manual, Lordship.
Oh, jail minutes. What is the heading of Rule 20?
Rules for superintendents and management of jails.
Rules for?
Superintendents and management of jails. The Lordship is having the same book, Lordship. It is at page 306.
No, it is framed under what? This is what kind of rules? My first question is, what kind of rules? Under what? Because it will depend upon the force of, then what kind of force it will have. Nothing is mentioned here. When it was framed,
Lordship, subject to correction, Lordship, may be under the Prisoners Act 1990, Lordship, these rules were there.
because there are laws that manuals are not having any enforceable. And that is why I am asking. All these provisions may not be enforceable in a writ petition. Right? There are judgments. There are judgments, police manuals are also not enforceable. That is why if it is framed under any statute, it may have enforceability. But it is not, then it will be mere guidelines. So that is the core, because in a writ petition, guidelines are not to be enforced. 226. But if it is some statutory flavor, color, yes, it is enforceable. That is a core question.
Lordship.
Now, here in the book, it is not nowhere mentioned. And there are judgments, these manuals are not enforceable. So before reading all these, first we have to ascertain what kind of rules are these, because you're all it appears that your petitions from page 14 or to 19
Lordship. This is
are rules are extracted.
Lordship. Based on these rules only, Lordship.
They are only where they are the inmate, my lord, they are allowed to, my lord, consume betel nut inside, they may be allowed to sell in the, my lord, jail canteen. That is there.
Okay, then let us proceed, then we'll find out
Yeah.
on which you are relying.
Lordship,
21.
Rule 21, Lordship.
Hmm.
The Board of Visitors shall pay a joint visit of inspection to the jail every quarter and individual visitors ordinarily once a fortnight. At each quarterly meeting of the Board of Chairmen shall draw up a roster of visits to be paid by each visitor during the next 3 months. The roster should ordinarily be drawn up so as to provide for fortnightly visits, but if any board expresses a desire for weekly visits, the chairman should arrange accordingly. Save in exceptional circumstances, visitors shall not visit the jail on holidays, but if considered necessary, permission to do so may be accorded to the same. May I skip to Rule 23? That is the role of the CGM here. I'm saying, Lordship, what happens, Lordship, once the Lordship visitor visits the premises, Lordship, inspection is done, and then there is a book whereby the person concerned will remark whether certain changes needs to be done, or and that particular remark is forwarded to the inspector of prisons, Lordship. And the particular changes in the jail premises, whether it's be the
Okay, let us read Rule 23.
A visitor's book shall be kept in every jail and shall be presented to the Board of Visitors and every individual visitors when the inspection of the jail has been completed. In this book, the Board of Visitors as well as individual visitors shall record the date and hour of their visit and any remarks they may desire to make. Such remarks should be limited to a statement and fair criticism of the actual facts which come to their knowledge, and to any suggestions they may wish the superintendent or the inspector general to consider. The superintendent shall note the action taken by him in the column provided for the purpose and shall forward copies of all such entries in the visitor's book to the inspector general. Shall be communicated to the visitor concerned. Whenever a visitor records remarks concerning the long detention of an underjail prisoner, a copy of
The superintendent note the action taken by him.
the other part doesn't concern us.
Yes. Never visitor records remarks. There is another copy of those remarks.
Lordship, here it says the suggestions they may wish the superintendent or the inspector general to consider. Lordship, their role is limited to the suggestion part only.
Yes.
Lordship, here what has happened, Lordship, the CGM by passing the order banning sale and consumption of betel nut has entrenched upon the power given to the Inspector General of Prisons. That is my case.
Now, what is the procedure regarding maintenance of jail canteens? In the rules,
Lordship, look at this.
is there provision for jail canteen?
Lordship, there is. Lordship, Rule 368 talks about the dietary provisions of
See,
368, Lordship, at page 400.
these are diets. Whether selling, purchase are permissible
Lordship,
inside the jail.
Lordship, it is the government.
First, you address on this issue.
Lordship, that is maintained by the government. There is no profit or loss in that, Lordship.
No, where is that? How can something can be purchased
Lordship,
inside a jail?
purchase is not the correct word.
Jail canteen.
Lordship,
No, you'll be purchasing the betel nut.
Lordship,
That is not provided free.
Lordship, Lordship, that the state only provide, Lordship.
Huh?
The government may be able to answer that, Lordship, because there is no profit or loss as such. Maybe the inmates, they do some work.
No, what is the provision for Mr. Handing? What kind of jail canteen? Huh? That samosas can be purchased. Huh? Switch can be purchased. No, diet is that fixed. Diet is fixed.
But canteen, my lord.
Canteen, I have not heard about canteen. No, yes, in universities, in mass, I have seen also this time also, that in mass, fixed meals, fixed time, fixed meals. When there is a canteen by the side of that mass, yes, you can purchase juice, cold drinks, biscuits, small shop. Whether this is inside the jail, it is probably because they are convicts. They are convicts or under trials. Whether this is, where is the concept first? If the jail is not jail canteen is not contemplated in law.
But there is a restriction in the prisoners, the officer cannot sell those are in section 9.
Of the
Prison Act 1890.
Pigeon Act 18,
Book my page 15.
page 50.
Page 15. Rule 9. Sorry, section 9.
Profit or no profit?
Officers not to have business dealing with the prisoners. No officer or person.
No officer of a prison shall sell or let, nor shall any person in transport or employed by him sell or let or derive any benefit from selling or letting any article to any prisoner or have any money or other business dealings, directly or indirectly, with any prisoner. So, no officer or shall let any person in trust for or employed by him sell or let.
Lordship.
Firstly, the C 226 is there. You are challenging something. But if the thing is itself illegal, if the running of a jail canteen where it's sale of betel nut is going on, if itself illegal, then court can take cognizance of it under 226. Irrespective of the fact that order of the CGM is admittedly illegal. Not justify your case whether running of a jail canteen to sell betel nut is permissible inside the jail. Can you show any provision? Because section 9 appears to be clear. Jail canteen, I have not seen any concept of jail canteen.
Let me have my instruction.
And canning is also illegal.
Huh?
If we follow this section 9, can establishment of canning is illegal.
Yes, it appears to be illegal.
In my lord, that my lord might have
No,
to,
it
my
might
lord,
for the
employers, lordship.
Not for the.
It is my lord provided for the employees only, my lord. That time they cannot go outside of the jail, lordship. That's why, my lord, it has been,
What was
some
it?
provision has been given. My lord, that for.
Page, you have said page 15. 1 May 97. Whether you have a right to purchase betel nut.
Lordship, here I'll try to find out.
Huh? If you have a right, then
Then, lordship.
then it will flow. But at the same time, there should be rights of inmates in the Assam Prisons Act 2013. Doesn't include anything. Right of inmate have the right to live with human dignity. So chewing of betel nut is not, cannot be equated or cannot be included with the live with human dignity. Then adequate diet, that is taken care of. Health and medical care. This is against medical care. Consumption is injurious to health. Betel nut.
Lordship, the question is.
No, question is whether you have a right to avail
That I'll have to find.
that facility. And whether inside a prison, you have to establish your right to have betel nut.
Lordship, I'll try to find it.
We can take cognizance of it. First, you have to say that you have a right to have betel nut. And secondly, also that a jail canteen, inmates are, because inside the cell, you have been given a cot or whatever, blanket and one pillow on this thing.
And also food also, my lord.
And plus food. And what are the rights? To have betel nut. Where is the right?
Whether they can any.
Only if there is a right, there is a mandamus. Irrespective of the any kind of illegality passed by the CGM.
Right.
That is, you cannot have betel nut. You may have a habit, but that does not mean that you have a right. As an inmate.
Whether they have the right to go and take some food or in the canteen or not. It is not.
That is what I have said, whether you have a right to have samosas. By going to the canteen, then everybody will order in Swiggy and Zomato.
Yes, tomorrow they will ask for more money. So like
Yes,
tomorrow they will ask for money.
they will ask for all these things. We have to take cognizance of all these facts. Just because CGM does not have the power, we'll also have to observe at the same time that you do not have the right. Show me your right to have betel nut inside the jail as an inmate. and plus convict. You are not even under trial. You are convict by,
That is lordship one of the ground because as indulgence, we are claiming that at least Bitternut may be given to us.
that is beyond.
They are sharing with the culture of the Assamese society, they say they may be allowed. That is their.
That is an
That culture inculcated, that is not there. It is not, it is by habit.
lordship that I'm not pressing lordship, the cultural part.
Show me your right.
Lordship.
To have another thing for consumption as a right, other than the diet provided by the jail authority. Have you come up with the prayer that diet was not proper? Unhealthy. Yes, you are asking for something unhealthy. Show me your right.
Lordship will give me some time. I'll try to find it out and.
Nothing will be next Tuesday.
Lordship.
Show me your right.
Only
And
for the-
show me that a jail canteen is permissible to be run to deal with all this.
Lordship.
Whether the
These two aspects,
prisoners can
lordship,
also,
I'll have my
Huh?
instruction.
whether have the prisoners, whether they can go.
Then everybody will ask for more once Bitternut is permitted. Everybody will ask for
Another
more.
interesting thing, lordship.
There should be,
Other districts, lordship, it is not banned. It's only with respect to central jail, Guwahati, lordship.
no, question of banning will not come. First, your right and permissibility of a jail canteen.
Lordship holds that it is not permissible, everything goes, lordship. The other jails also will be. I understand.
We may hold that CGM is not authorized, but
Lordship.
question of running a canteen
Lordship.
and selling Bitternut there
Itself
itself is illegal.
Lordship.
And inmates and convicts do not have that right to ask for a writ in the nature of mandamus. So you overcome that
Lordship.
obstacle.
Next Tuesday, lordship.
Yes, Mr.
P. Das.
Okay, on the prayer of Mr. P. Das, Learned Counsel for the petitioner, is the case on next Tuesday. Mr. J. Hendik, Learned State Counsel for the respondent number 1 to 4, and Mr. T.J. Mohata, Learned Senior Counsel, and Standing Counsel, GHC, for the respondent number 5 are present.
Obliged.
For 2 weeks.
You are for the?
I am for the petitioner.
Okay. Ms. A.G. Burwa, Learned Counsel for the petition has made a prayer for adjournment. We have informed our sides. Come out with the consent of the Learned Counsel for the respondents, full stop. Memo, yes. It is submitted that a mentioned memo to the effect has already been circulated yesterday. Post of. As prayed for by MS Burwal and Counsel for the petitioner, is the case after 2 weeks on a date to be fixed by the office.
Number 12.
9. Yes, MS Bormon.
My lord, in this petition, petitioner had challenged the order dated 3/2/2017, passed in Miss case 17 of 16 by the Executive Magistrate Subdivision West Garo Hills. West Garo Hills.
No jurisdiction.
145 proceeding, my lord, whereby his plan was attached on a complaint made by respondent number 8, my lord.
With agreed by an inquiry report and also by an order. Where is this land situated?
According to our affidavit, my lord, he has patta land in Gwalpara district, my lord. And so far as land of the respondent number 8 is concerned, my lord.
So this inquiry report, Miss case number 27 of 2016, where is that order?
That order is at page 28 of the petition.
28.
28. at 145%. Legally, it is inquiry. This
This is the order.
36 is the order, my lord. 36,
Huh?
page 36, 38,
36.
36. Yes, ma'am.
This case number Nogen Rava.
Relevant page is 38.
And what is this report? Inquiry report. What is the basis of filing this petition here?
He applied for demarcation, my lord. He stated that 145 proceeding due to non-demarcation that wrong order has been passed, but that order was also ex parte, according to him.
Gwalpara. Now, where is the land father of the petitioner? Had purchased Miadi Potta 1 bigha Potta number so and so. Kotia number so and so. Village college are located the district recorded land. Who is that? What is the name of the petitioner? Abu Asad Anwarul Islam. And
His father's name is, my lord, name is on his father's.
what are the impugn orders? Where you said page? He is Anwarul Islam. That is impugn order is page
3 to 17, that is page 38, my lord.
38. Anwarul Islam, same thing.
Yes, my lord.
Same. Haji
He had challenged the.
Haji Panaullah Ahmed. So he submitted to the jurisdiction of that particular court in the proceeding. First, he submitted himself. He contested. Then his challenge is to be before the Meghalaya High Court.
That is why one of the order sheet, my lord, maintainability issue has already been.
Firstly, he submitted to the jurisdiction. When the notice was issued to him, he did not raise the jurisdiction. He contested. Right? Thereafter, this order has been passed. So, if the magistrate does not have the jurisdiction
To have.
or to have challenged it before,
For that.
okay,
right.
we put it day after tomorrow. We'll give a chance, non-absence. Then I will close. Yes, Mr. Handy. At least a chance.
Name is already. written.
Why it has been pending for returnable?
Maintainability issue has already been raised by another court, my lord.
Where? Which order?
Order I could not reflect, but I have.
In your affidavit.
I have checked the earlier orders. Date I forgot to put my.
Huh?
But it is reflected in order sheet, my.
Maintainability. There is no representation on behalf of the petitioner today on call. So stop. You represent revenue. Mr. J. Henry Clarence Standing Counsel. Revenue, MS M. Borman, learned junior government advocate for the Assam, for the respondent number 1, 4, 5, 6, 7. And Mr. J. Henry, learned Standing Counsel, Revenue and Disaster Management Department for the respondent number 2 and 3 are present. Full stop. In this writ petition, comma, the writ petitioner has challenged an inquiry report dated 12/5/2016. Annexer. Annexer 4.
Page 28.
Submitted by
It is Annexer 7, page 30.
the in charge, comma, Bogula R. Vita Police Outpost. Post Office, Bogula Vita, Post Office, Holai Danga, District, West Garo Hills, Meghalaya. Within bracket, the respondent number 10. And an order dated 3/2/2017, passed in Miss Case number 27/2016. That is Annexer
7.
7. Passed by the so and so, passed in Miss Case number so, by the additional district magistrate within bracket executive, comma, Dadangre, page
38.
36 silo or 38 silo. Civil subdivision, comma, district West Garo Hills, Meghalaya. Within bracket the respondent number 8. On the ground that they were the inquiry report and the order, comma, impugned hearing, comma, are without jurisdiction and without any authority of law. Full stop. A direction in the nature of mandamus has also been sought for to direct the respondent authorities to make proper and permanent demarcation of the parcels of land, comma, claimed to have belonged to him, claimed to have belonged to a petitioner within the Lakhipur Revenue Circle, District Goalpara. Yes, so far second direction is concerned.
That part he has.
First
rejected.
part is obviously not.
Affidavit has filed, my lord. We have filed affidavit in that we are
Stop.
having a stand that his father has land, my lord. So that part is admitted by the state authorities, and accordingly, he has filed a demarcation application that was received on 29/3/17, para 9 of our affidavit. In that matter, DC has stated that it was forwarded to the assistant settlement officer for doing the need. Demarcation outcome is not stated in the affidavit. So in that case, lordship may direct, if that application is pending, that may be taken into account as per law. By the
So
ASO.
first prayer is concerned
That cannot be granted, madam. For that he
and
has,
third prayer is also concerned not to dispose. We
because
can give
enrichment
the,
order has been passed in the meantime, probably, so he has in 145 proceeding, my lord. So that is why he make a parallel prayer of not to evict him.
that is why perhaps the notice was issued.
Yes, madam.
There are period of the limitation, there are limited period. It might have been my lord.
It is, it might.
No,
have been-
attachment order passed by whom? That subdivision, that we cannot interfere.
This cannot be, but they have the jurisdiction in.
Meghalaya.
So far as demarcation prayer is concerned,
That can be my lord pass an order, not the concerned authorities
As
for the demarcation as per
as-
law.
okay.
affidavit admitted. that-
As there is no representation on behalf of the petitioner today on call. Oh, হেৰি লিখিছো নে এইখিনি লিখিছিলো ন প্ৰেজেণ্ট লিখিছো ন list the case next Tuesday list the case again on next Tuesday. Name of the Learned Standing Council, Revenue and Disaster Management Department be reflected in the respondent side in the cost list.